All right, let's jump right in. We're going to talk about something that happens to all of us. You buy something, and it just goes wrong. So, what can you do about it? Well, today we're breaking down your fundamental rights as a buyer under UK law. Seriously, we've all been there, right? You get that shiny new gadget home, you're all excited, and it's broken. Or maybe it's not what you thought it was, or it just falls apart after a week. It's so frustrating. But what are your actual legal rights? The answer has changed a lot over the years. For a long, long time, the rule of the game was caveat emptor. It's Latin, and it basically means let the buyer beware. It was this really harsh world where you, the buyer, had to check every little thing yourself. And if you missed something, tough luck. The seller had almost no responsibility. Thankfully, things are very, very different now. Okay, so the first and maybe the most obvious right the law now gives you is that the seller has to, well, actually have the right to sell the thing in the first place. I know, it sounds like a no-brainer, but this is the absolute bedrock of modern consumer protection. Let's look at a classic case that shows exactly why this is so important.
So picture this. There's a car dealer, Rowland. He buys a car for 334 quid, gives it a new coat of paint, and sells it on to a customer for £400. Everybody's happy. But then, 4 months later, the police knock on the door. Turns out, the car was stolen. They repossess it, and of course, Rowland has to give his customer a full refund. Now he's out of pocket.
So here's the big question. Rowland technically had the car for a few months before he sold it. So when he goes back to the guy who sold it to him, Divall, can he get a full refund or should some money be knocked off because, he had the car for a while? What do you think is fair? And the court's answer was a resounding yes, full refund. And the reason why is so, so important. The court said that when you buy something, you're not just paying to use it for a while. You're paying for the legal right to own it, what the law calls valid title. Since Rowland never legally owned that car, the deal was a complete failure from the start. He was entitled to every penny back. Okay, so let's build on that. The next key right is that the item has to match its description. And we're not just talking about small details here. We're talking about the fundamental identity of the thing you're buying. And oh boy, this next case is a wild one. A guy named Beale sees an ad for a 1961 Triumph Herald. He goes and checks out the car. It looks okay, so he buys it. But later, he discovers it's a Frankenstein's monster of a car. The back half of a 1961 model had been literally welded onto the front half of a much older model. Crazy, right? Yeah, no surprise here. The court had no problem finding this was a massive breach of the contract. Even though the buyer saw the car in person, he was relying on that description, 1961 Triumph Herald. And what he got just wasn't that. The identity was wrong. The point is simple. The thing you buy has to be what they say it is. Okay, so the seller actually owns the thing, and it matches the description. But is it any good? This is where the law has made one of its biggest leaps forward, raising the bar from just usable to something much, much better for us consumers. The old test was for something called merchantable quality, and honestly, the bar was ridiculously low. It basically asked, can it be used for something? So a brand new car with a giant scratch all down the side, well, you can still drive it, so it would have passed that test. The new test is for satisfactory quality, and it's a game changer. It asks, would a normal, reasonable person find this product acceptable, considering the price, the description, and everything else? That scratched-up car would fail this new test in a heartbeat. So what does satisfactory quality actually mean in practice? Well, the law breaks it down into these 5 key pillars. It has to be fit for all the things it's normally used for. Its appearance and finish have to be up to scratch. It should be free from even minor defects. It absolutely 100% has to be safe. And it needs to be durable enough to last for a reasonable amount of time. And I love this quote from a real case about a faulty new Range Rover. It just sums it all up perfectly. The court said that when you buy a premium car, you're not just paying for a metal box that gets you from A to B. You're paying for comfort, for ease of use, and even for the pride of owning it. Quality, you see, is about the entire experience. So far, we've talked about what a product is normally used for. But what if you need something for a very specific, maybe even an unusual reason? Well, that brings us to our final key right, fitness for a particular purpose. Let's look at this story. A woman buys a really nice Harris tweed coat. But after she wears it, she gets a terrible skin rash, dermatitis. Now, it turns out the coat itself is perfectly fine for pretty much everyone, but she just happens to have abnormally sensitive skin. So she sues the seller. So what did the court say? Well, they sided with the seller. The coat was fit for its normal purpose. The catch was the buyer had a special requirement that the coat be okay for her highly sensitive skin, and she never told the seller. Because she didn't say anything, the seller couldn't possibly have known. The takeaway is crystal clear. If you need something for a special reason, you have to speak up and make it known. So, when you put this all together, we've come a long, long way from that old world where the buyer was on their own. Today, the seller has some pretty significant responsibilities. Remember how we started with caveat emptor, let the buyer beware? Well, today, the situation is basically flipped. It's much closer to caveat venditor, let the seller beware. The legal balance has totally shifted, putting the responsibility squarely on businesses to sell you goods that are up to snuff. So here they are, your 4 key rights in a nutshell. Think of these as your consumer superpowers. 1, the seller has to have the right to sell it. 2, the product has to match its description. 3, it has to be of satisfactory quality. And 4, if you told the seller you need it for a specific job, it has to be fit for that job. These are incredibly powerful protections. Now, this table looks a bit legal, I get it, but I want you to look at that final column, the one that says status of term. See how all 4 of our rights are listed as a condition? That little word isn't just jargon. It's the key to your most powerful weapon when a purchase goes wrong. So what's a condition? Think of it as a fundamental, deal-breaker part of the contract. If a seller breaks a condition, like selling you a faulty laptop or a car that isn't as described, you generally have the right to reject the whole thing, end the contract, and get a full refund. That's huge. It's way more powerful than a warranty, which is a more minor term. If a warranty is breached, you can usually only claim damages, like the cost of a repair. So there you have it. From buyer beware to seller beware, the law now gives us all a really strong safety net. The next time you go to buy something, remember, you're not just buying a product, you're buying a whole set of legal rights that come with it. So knowing all this, does it change how you'll think about your next big purchase?